Hey everybody, Daniel Sherman here. As I said on my earlier videos, my Facebook feed and the algorithm leads me down a rabbit hole. So what's been showing up on my feed is some of the Young Thug trial, and I just want to say a few things about it. And I'm saying this today because spring break starts. And I am going to have a lot of phone calls when spring break is over for people who have violated court orders for not complying with spring break. Every holiday, Christmas is usually a big one, and then I'll get them over the summer. Other parent, I was supposed to have spring break, but they already made plans, and they didn't give me the child or children, and what do I do? So that is part of what I want to say, but I also want to say about a little bit of the conduct of the defense attorney. He's a really good defense attorney. He's, an attorney's attorney, so to speak. And I say that because he's willing to go to jail for his client. I've always, said that I would be willing to go to jail for my client. I really haven't. I've only been presented the opportunity once, and the officer ended up backing down. It was they wanted me to provide a cell phone. I said I'm not providing it. It was my client's cell phone. He had given it to me, and I was a younger lawyer, but I was like, no, you're not. I'm sorry, you're not getting it. You got a warrant. Go ahead, but you're not. I don't care if he's a drug dealer. You're not getting his cell phone. He gave it to me. It's mine. So, but there really was no, there was some intimidation, but there was no, I'm going to take your ass to jail or anything like that. So, and he was a younger officer as well. So I think we butted heads a little bit, but, it was what it was. And I think I ended up just putting it, he gave it back to him, put it in his jail property, took it over to the jail. So, I didn't have to mess with it, and if they wanted a warrant, I didn't want them to come to my house. So, but yeah, so that's that. Anyway, so this lawyer had gotten some word from I wouldn't say an informant, but somebody that the judge had what's called an ex parte communication, and what that is that's a conversation where one attorney is present and the other attorney is not. Anytime you talk to a judge, especially if it's regarding, a case in front of him that you're a part of, the other side should either be there, be aware of it. If you send an email to the judge, you should always copy the other attorney so everybody, there's no secret and everybody kind of knows what's on the table. Well, this attorney for Young Thug had found out that the prosecutor, the judge, and one of the witnesses had a conversation. And I don't know if it was recorded, if the record was still going, but I think it was in chambers. And the attorney brought it up. He said, this man is on trial, and you guys are doing this stupid stuff. Not to do it. And the judge was pissed. Not necessarily, he was pissed because he got caught. And, he said, well, I need to know the source of who told you that, because it'll only be a few people. I need to know. And that attorney was like, I ain't telling you. And the judge was like, well, if you don't, I'm going to hold you in contempt. And he's like, I ain't telling you. So, and it was a great scene, and I'm sure he probably has now got a lot of new clients. Took off his jacket, was like, let's go. I'm willing to go to jail. And, and then, they were taking him to jail. And then the co-counsel's like, well, we can't try the rest of this case because you just put my client's attorney in jail, and he has a right to his attorney, and here's where we are. And I think at the end of the day, the judge backed down, but that's something that, is, and there's been some other issues in that trial. The defense attorney is really good. And there's there's been a lot of things that should not have come into that trial. I'll just mention one more thing until I get to really what I want to talk about. The police officer had said on the stand, and this was unprompted, that he had known young Thug had been in and out of prison. Well, when you're on a criminal trial, you cannot mention somebody's character, their criminal history, especially from a third party. You can't mention that at all. Like, that is one of the biggest no-nos, and really should result in a mistrial. And the issue was, the defense, I think, was well taken. This was a seasoned officer. This was somebody who had 30 years under his belt and testified in hundreds of trials. Like, he knows not to say that, and he said it. And the Commonwealth, and I think even the defense attorney said, look, the Commonwealth, they didn't ask the question like, hey, have you seen this guy in and out of prison? Or, they didn't ask a question to elicit that. But, that was, something else. I guess another side note, geez, I'm doing side notes today. I had that happen in a trial. Actually, the officer, it was I think the last manufacturing trial in the county. We got a not guilty verdict. But one of the co-defendants, wasn't my client, one of the co-defendants had been arrested a couple times by the officer. And, the question was, okay, do you know this guy? And, can you point him out? And he's like, yeah, I know him. I've arrested him. And so, like, we go up and we're like, oh my gosh. Like, we specifically, like, all in chambers, specifically told this officer not to say it. Even the prosecutor was like, don't say this. We know this is how you know him because you've arrested him at least twice, but just, don't say it. And of course he said it. So we went to court, went to the judge. Hey, judge, move for a mistrial. We warned him. Justice no. Admonishes the jury, and then we move on. Very next answer is, I arrested him. So we just, and the prosecutor just kind of, it was Ralph Vick, he just kind of put his head down and was just shaking his head. And, I was like, I didn't do this, guys. And, like, it wasn't his fault, but, he was a younger officer. Well, wasn't younger, he's not younger now, but, and if he's listening, he knows who he is. But we ended up getting a not guilty verdict, and the jury walked all three, which again I think was the right verdict. But that was that happens. So anyway, so if you're following the Young Thug trial, that's really what you should do. But really, what I want to talk about is the issue of contempt. All you contemptuouses out there that are going to violate the court orders over spring break, I just want to explain to you what you're about to do and what the issue of contempt is, because even though the defense attorney was a very, very, I thought, capable attorney, he didn't understand it. Like, they're trying to read from law books, like they don't understand contempt, and the judge doesn't understand contempt, because the issue is whether or not they were entitled to a hearing. So I want to go about the different kinds of contempt. So first of all, you have, and I'm going to deal this way, direct contempt or indirect contempt. Now, direct contempt occurs in front of the judge. Like, the judge is very well aware it's in front of the judge. So an example of that would be if a court issues an order for somebody to bring somebody to court or bring a document to court. That person doesn't bring the document. Well, the judge is looking right at the person. No motion needs to be filed. The judge is looking at the person, and the person is clearly in contempt. That was the court's order to bring something to court. They didn't do it. So that would be a direct contempt. Another example of a direct contempt is if you were to say to the court, judge, F you, I don't like what you're doing here. A lot of times you'll see, I'm gonna hold you in contempt, or they do hold them in contempt. That is direct contempt. It's in front of the judge, basically. Okay, so, and then you have what's called indirect contempt. Indirect contempt occurs outside of the purview of the court. So, for example, if, in Matt Bevin's case, where he's supposed to go to jail, he was supposed to provide to the other attorney certain financial documents. He was ordered to do so multiple times. He didn't do so. So the court found him in contempt. But that is indirect contempt. That is outside of the purview of the court. Another example of an indirect contempt, which happened in this county, and it may have been published a little bit. Some of you may have heard it. If an attorney says some really bad things about a judge that's inappropriate, that's not necessarily in front of the judge. That could be considered indirect contempt. But most of the time you get it with discovery violations and failure to produce documents, or child support's a really big one where, you didn't pay child support. That could be indirect contempt. Okay, so those are the two, indirect and direct. Then you have criminal contempt and civil contempt. And those serve two different kind of purposes. So criminal contempt is meant to just punish somebody. Like, you were told to do this, you didn't do it, or you did something you weren't supposed to. I'm putting you in jail, okay? I'm punishing you for it. Civil contempt is, you can still be put in jail, but it's designed to have something produced. So I'll give the Matt Bevin example. That's a civil contempt. It's an indirect civil contempt in the sense that they're just trying to get him to produce something. They're not trying to punish him. So they're just trying to say, produce the documents. And so if he produced the document, he could do what's called purge himself of contempt. A lot of times that happens. You'll see it with like payment of fines or child support cases. Hey, look, you pay this, we'll whatever sentence we're going to give you, you are, whatever sentence you're given, we'll suspend or get rid of as long as you provide the documents. That's civil contempt. Again, criminal contempt is to punish you. Like, so for instance, if you told the judge to F off, or, you're extremely unruly in the courtroom, it's not really, it's designed to say, listen, you disrupted something. I'm going to have to punish you. And that's most of the time you'll see direct or criminal contempt. And each of those are direct and indirect criminal contempt. Now, the big issue was, in the Young Thug trial, the court held him in contempt for not providing the documents, or not providing the name. And so the issue was whether or not he would have been entitled to a bond. So then it became, so is it civil contempt? Is it criminal contempt? Is it direct contempt, or is it indirect contempt? Because if it's direct contempt, you're typically not entitled to a hearing. And the reason you're not entitled to a hearing, because it's right in front of the judge. He's the one that's making the decision. It's like a summary judgment. You did it. I saw it. We don't have to put any evidence on. Like, I'm the witness and I'm the decider. So you don't have to have a hearing. Now, if it's indirect, typically you will have a hearing. And then the issue, was, if it was criminal, could he post a bond and appeal it? Or if it was civil, he couldn't post a bond. And so they were trying to figure all this shit out. And they just could not get it. And the real argument was, if I disclose this, I'm violating, my duty to my client. So it's not something I can disclose. So his argument was it was criminal contempt. And because he wanted criminal contempt, because he wanted a bond. Now, because it was direct, he would not have been entitled to a hearing, but he very well would have been entitled to a bond. And the reason is if you're going to appeal, it's harder to appeal a civil contempt because, like, all you have to do is just produce it. Like, the Court of Appeals is and that's why you don't get a bond typically, because just produce the damn documents and you don't, I mean, that's your bond. So that was the real issue, that they were kind of arguing back and forth, and just to watch, a seasoned judge and some seasoned lawyers that just could not grasp that concept. And I don't even know I'm explaining it. It's a little convoluted, but basically, if it's in front of the judge, it's direct. If it's not in front of the judge, it's indirect. If it's designed to punish you, it's criminal. And if it's designed to produce something or comply with a court's order, then it's civil. So that's all you need to know. And the differences are, some of them you're entitled to a hearing, and so you'd be entitled to an attorney and things like that. But yeah, I've seen it a couple times. The last example I saw was when somebody had filed in the record a fake doctor's note. They had missed court, and they forged a doctor's note, and that was in the file. That was really, I mean, there's no cure for that. So that's criminal contempt. It's where you're going to be punished. And then, I don't necessarily, it kind of occurred in front of the judge. So it's kind of a mix of indirect and direct. But, that was one. And the court actually, I don't think the court had to, but the court went ahead and appointed the person an attorney, because I think a good argument could be made it was direct contempt because it was, done in the file that's sitting right in front of the judge. But, probably, I guess it was probably more indirect contempt because they did have to call the hospital and make sure that they weren't the ones who wrote the note. So that's an example. God, 17 minutes. So hope you all have a good day, and have a good spring break. And just remember, call me when your former significant other, baby mama, baby daddy, doesn't give you the kid for spring break and they're supposed to. Take care.